I'm glad that y'all are joining us today, and let's jump right in and look at some of the biggest issues that we see with our clients as far as problems in the harassment area. And the first one is failure to recognize harassment based on traits other than sex. So many times our employers focus only on sex harassment when the focus these days really is on items such as racial harassment, disability harassment, age harassment. So while we've all been trained to be concerned about sex harassment, the bigger issues are popping up in all of the other protected categories. The second issue is lack of a very clearly communicated and comprehensive policy and a reporting procedure on the prevention of harassment and discrimination for that matter. This policy, if it's properly drafted, if it's properly updated, and if you train everyone in the organization on it, is going to be your first line of defense. So this is absolutely critical, but is one of those areas that just doesn't get as much attention as we would like it. The third area is failure to investigate reported complaints. Many, many times what we see is that an issue was actually reported using a reporting procedure, but it was delivered to a manager who was not aware of their legal obligations or the company's legal obligations under the policy. So if it's the lower level manager who would rather bury their head in the sand and hope that it goes away, then the employer gets stuck with a really big issue. So again, this ties back into the training everyone in the organization on the policy about what happens when a harassment issue is noticed in the workplace or when it's actually been reported to someone. Along those same lines, we see issues with clients failing to investigate unreported behavior. A lot of times we'll hear people say, well, if no one complains, it's not an issue. And unfortunately, that's not the standard. That's not the legal standard. If you knew or you should have known about it, particularly in situations where you've got employees, a non-supervisor situation, so you've got coworkers engaging in harassing type behavior and it's kind of open and out in the environment, but no one that has authority to do something about it does anything about it, you can also find yourself in a sticky legal issue there as well. Finally, as with most of our employment claims, the failure to document just continues to be an issue in this area as well, or failure to document taking corrective action or documenting that corrective action. So again, just like every other issue when you've got an employee performance problem and you want to get that file stacked, you want the same thing in these harassment types of cases. All right, now I don't want to go into any great detail here. I'm sure everyone's familiar with the major federal laws preventing discrimination, but what I want to just remind everyone that each of these major federal discrimination laws also prohibit harassment. So every single one of these characteristics and traits could potentially be the basis for a harassment lawsuit as well, including the new Genetic Information and Non-Discrimination Act, although I have to say we haven't seen any of those claims just yet. And additionally, each of these statutes also prohibit retaliation. You want to really make sure that policy is covering this, that your training is covering this, and that your managers really understand their obligations when it comes to retaliation and what to do and what not to do when they are the subject of a complaint. And as you all are quite aware, the lawsuits in these areas can run hundreds of thousands of dollars in damages and attorney's fees as well. Along those same lines, depending on where you have employees working, you want to make sure that your state laws are being reviewed and your local laws, because each of, there's so many jurisdictions that have laws that prohibit discrimination and harassment that are areas that are much broader than the federal statutes. And something else to think about, which we don't normally think about until the lawsuit actually hits, are state law tort claims. So intentional infliction of emotional distress is a big one that we see attached to any sort of harassment lawsuit. Negligent hiring, negligent training, negligent supervision. Again, did you know or should you have known that you had an employee engaging in behavior and didn't do anything about it? And the problem with these state claims is, unlike the federal statutes where you have protection from individual liability, that's not necessarily so with some of these state law tort claims. In your training of your managers, you want to basically let them know that this is serious. It's not just the company that might be on the hook, that your managers and your supervisors really have to understand that their pocketbook might get hit too. So just a couple of things that sets up why all of this is important. And now when we're talking about harassment, there are two major types of unlawful harassment claims, and the first is hostile work environment. This is typically thought of as sexually hostile work environment, but again, it applies to every protected category. And the second is the quid pro quo. If you scratch my back, I'll scratch yours. And by and large, we don't see these claims anymore, and this is in the sexual harassment category. They're out there every once in a while, but I really think the focus for each of you should be, and probably is, on the hostile work environment, because that's where you really have to look at the situation closely and determine what behavior is going on. Does it rise to the level of something that's unlawful? And so with that in mind, let's talk about what types of behaviors your managers, your supervisors need to be looking for. Aside from having someone just coming to complain to a manager, what types of things might be out there that might tip you off that you might have a harassment issue? And most of this stuff is really quite obvious, but when you put your managers on task of taking a proactive approach for looking for things, they're in a much better position to go ahead and address it before it becomes a problem. And again, most of this stuff you're already familiar with. I will say that I'd like to talk about a couple of these. One is the comments reflecting stereotypes and questions and comments about sexual orientation. Now, some of you may be in jurisdictions where your state law, your local law, prohibits discrimination and harassment on sexual orientation. Federal law does not yet, and there are several states that also does not protect this category. However, if you have a situation where you've got comments about basically call into question someone's gender stereotype, whether they're manly enough, whether they're feminine enough, that really gets close to the line of whether or not you're talking about someone's sexual orientation. So we see a lot of these stereotype cases in the sexual orientation context, and even if federal or state law doesn't protect sexual orientation, it will cover a situation where someone is being picked on and called names because they don't fit the traditional gender stereotype. All right, this is where I think with sex harassment in particular, the physical contact typically drives the damages up in these types of cases. And one that I want to call out here is the shoulder and back rubs, because it seems like almost all of our clients seem to have that one employee who just loves to hand out the back rubs, and quite frankly, most people don't mind getting them. But this is the exact type of behavior that if you notice it in your workplace, that you're going to want to go ahead and address it before it turns into a problem. Because if you let this type of behavior carry on, and it might seem that it's consensual and it might seem that it's okay, but this is the stuff that, you know, when relationships don't work out and everyone knows that Jim is always handing out the back rubs but no one's done anything about it, you're going to be stuck in a sticky situation. The other major form that harassment comes in is in objects or images or gestures, and typically, for example, a lot of race harassment lawsuits involve a photograph or some sort of image of a noose, for example, and that's something clearly everyone would notice and would address. But the one that I want to pull out on this particular slide is the emails, because you're not always going to know what your employees are sending to each other via email or showing to each other on their computer screens. This is one of those things where you really need to make sure that your harassment policy covers this area. And in addition, you'll want to have, you probably already do have, a standalone email and internet use policy, and you want to basically track that same language that you have in your harassment policy and insert it into your email and internet use policy so that all of your employees are aware that while you may not be watching them 100% of the time, they absolutely can't be exchanging discriminatory, harassing type of material via email, because that's the stuff that once it's out there, and there's little that we can do from a defense standpoint. All right, so a couple of real quick other points before we get into some preventative tips that I want to make sure everyone is doing. First, who can be a harasser? It's not always limited just to your employees and just to your managers. If you are dealing with, if you have vendors coming in to work in your workspace, if you have consultants, if you have hotel guests coming, they can certainly be the source of harassment. So you want to make sure that your policy is covering all of these types of players. And likewise, harassment's not always something that is limited to the time that your employee is on the clock and doing work. If they're on a break during lunch, if they're on a business trip, if they're at a holiday party, harassment can certainly occur. So all of this stuff is stuff that ideally will be wrapped up nicely in your very comprehensive policy. All right, so let's get into the real checklist here about some things that you can do to really reduce, if not stop, all of your harassment claims. And certainly, if you get one, this will set you up for the best possible defense of any type of harassment claim. So first and foremost, I think I've said it a lot today already, and it's only been a few minutes, but this is really critical. It's implementing and enforcing that comprehensive policy against discrimination, harassment, and retaliation. A lot of clients will update their handbooks on an annual basis. Sometimes that doesn't happen, but if there's one thing that you do update annually, this is the policy that you really want to make sure is solid every year, particularly as additional protected categories are added into federal law, state law, local laws. Second, you want to make sure that all of your employees, all of your supervisors are trained on this policy. The policy is great standing alone, but if no one really knows what to do with it or what it prevents or what its purpose is, it's not going to do you a tremendous amount of good. The policy would still certainly help you in the defense of a claim, but if you really want to make sure that it's an effective policy so that problems are stopped before they really get started, you'll make sure that everyone understands what their obligations are under the policy. When you're training your supervisors, it's absolutely critical they understand the prohibition on retaliation. Again, your policy will have a statement in there about retaliation being prohibited, but it gets very difficult for managers on just a human level when they are the subject of a harassment complaint to separate their feelings for the employee that's complaining about them and their role as a supervisor. So they need to understand that there are certain things that they can and can't do. Certainly they're not going to let their employees be able to do what they want and call all the shots, but they need to remember that they cannot treat those employees differently or take any sort of action against them that would be viewed as unfavorable following a complaint. Moving on, the next item is once you receive a complaint or once you have information just from observation in your workplace that there is a potential issue of harassment, you want to conduct a complete and thorough investigation, and we'll go through just a few steps that are important there in a moment. Finally, once your investigation is complete, you want to immediately take some remedial action. Stop any behavior that you've identified, if you've identified any at all, and do some follow-up work that we'll go into in just a minute as well. So let's start with your policy. So with these points in mind, you can, and there's more to it, but these are some of the major ones that you want to go back and look at your policies right now and see, does my policy have all this stuff in it? One, is it preventing all forms of harassment, or is it just sex harassment? And these days, I think most policies are, but just a week ago, I had an employer call me and say that they have an issue with national origin harassment, but their policy is still from years ago and really only can prohibit sexual harassment. So they're rushing to get their policy updated. This is critical. Does your policy have a clear reporting procedure? And does it include alternative reporting channels? Because it really won't matter to a judge or a jury if you have a policy in place that tells your employee to complain to the harasser or complain to their supervisor if the supervisor is the one doing the harassment, if you do not give them an alternative way in which to file that complaint. We see this in a lot of different ways. It's either, depending on the size of your organization, it could be following up with human resources. It could be taking it to a higher level of management. It could be providing a 1-800 confidential number, and ideally I think we would have all of our clients do that. I know that's not the easiest thing to do for everyone, but the more avenues you give your employees to complain about any issues they have, the more likely you're going to hear about a problem before it gets to be a costly problem, and the more you can actually go ahead and get it addressed. Next, does your policy have consequences, both for employees who engage in harassing and discriminating behavior, so that they understand that if they take some of the actions that we were talking about earlier, that they will be subject to discipline and possible termination? And likewise, is there something in there so that your managers face consequences as well when they become aware of harassing issues but fail to carry out their duties to ensure that the behavior actually gets addressed? Next, you really want to make sure that you have a standalone prohibition on retaliation, that employees understand that they can raise any issue of discrimination, any issue of harassment using your policy, and that they don't have any concerns of being retaliated against for doing that, because we hear that so many times, that people didn't want to complain because they were afraid they were going to lose their job or suffer some other unfortunate event. And because retaliation claims are on the rise, this is something that I would recommend not just including a sentence on, but perhaps within your policy having a sub-policy preventing retaliation. And finally, do you retain signed copies of your policy against harassment and discrimination in the employee files? Hopefully you do. Now, many of our clients will just include the policy against harassment and discrimination in their employee handbook and have the employee acknowledge that they received and read the handbook, and that form goes into the file. Now, that's helpful and great, and sometimes we don't even have that. So if you've got that, that's fantastic. But what I really like for our clients to do is to take the policy, keep it in the handbook, obviously, but just cut and paste it into a standalone document that the employee reads separately from the employee handbook. And it's just your policy prohibiting discrimination, harassment, and retaliation. And you have them read that, and you have them perhaps initial some of the important passages, and make sure they have a copy and keep a copy of that in the personnel file as well. That has been very effective for us as we've been defending claims alleging harassment and discrimination. Okay, so you've got your complaint of harassment, and let's talk first about what not to do. And a lot of this stuff seems like common sense, but I really do need to point out that this stuff happens a lot. In fact, we had one client who I think engaged in all of this behavior when they received a complaint from an employee who was saying that other employees were picking on him. They were calling him flower boy. They were calling him pansy. They were engaging in wrestling moves with him. And this particular client was a fairly male-dominated client and had somewhat of a locker room environment anyway. But because of all of this stuff that our client just thought was normal, the manager basically laughed at the complaint, told the complaining employee that he really had better stop complaining about it, because if he didn't, that would just make the problem worse. They ended up terminating him, and unfortunately, it was just one of those things where the manager just brushed it off. And to him, the manager thought, well, this is really trivial. This is the behavior that goes around here anyway, and the guys pick on each other, and it's not that big of a deal. So in the manager's mind, this is a very trivial issue. But at the end of the day, that complaining employee got a pretty fat settlement check because nothing was done properly. In fact, everything that could have gone wrong went wrong in that case. So take note of these things of what not to do. Okay, so what should we be doing? First and foremost, I always like for our employers to thank the employee for bringing the issue to their attention. If you've never been in a situation where you felt like you've suffered some sort of harassment and discrimination, we hear time and again that it is very upsetting, it's very nerve-wracking. When people legitimately are suffering some sort of issue, it is very difficult for them to even talk about it. And again, you're going to be in a better place if you have the information so you can stop it before it turns into a lawsuit that you had no chance to even handle. So I think it's important that the employees know that it's important to you that you're taking their concerns seriously and that they were brave enough to come and talk to you about it. Secondly, once you've got that information, you immediately need to consult upper-level management, definitely human resources to the extent you've got that, and legal counsel. Sometimes when you're devising your investigation plan, parts of the investigation can be covered and kept privileged depending on a variety of issues, but you always want to make sure that your managers understand that when they get these complaints, they need to be involving the entire team, truly, so that you'll have the best investigation plan in place and be able to prevent additional issues. Along these same lines, when you're talking about your plan, if your complaint is from an employee who is complaining about a manager, a direct manager, at that point you really do want to take immediate temporary action and perhaps temporarily split the complaining employee and the supervisor, place one or both on suspension until the investigation has been complete. You know, whatever makes sense in the situation. And again, this is really something that is a case-by-case basis and going to depend on the facts. Some complaints aren't going to be severe enough that would warrant a decision like that. But if you do have allegations of any sort of bodily contact, I think in the sex harassment category, or just any sort of egregious behavior related to any of the protected categories, that you make some sort of move there. During your investigation and early on, the first thing that you're going to want to do is get the full account from the employee that is complaining. And ideally, this will be a written statement from them that details every instance of alleged harassment. What this does is not only help you frame your investigation plan, but down the road, it really boxes the employee into what their story was at that time, when it was happening, when it was most fresh on their minds, and certainly before any plaintiff's lawyer comes in and tries to embellish that complaint before the EEOC. So this is a really critical step. And once you have the written statement from your complaining employee, then you go forward with your investigation plan, with your interviewing witnesses and collecting additional evidence as you need. But again, this is not something that we would recommend that anyone tackle on their own. It really should be a part of a collective decision about what is the best way to approach this plan with human resources management and counsel. Once your investigation is complete, that's when you need to determine what sort of action to take. And a lot of times what we find in an investigation is the allegations were made, but we couldn't find any other evidence to substantiate it. So a lot of times employers just won't take any action at that point, which I think is probably a mistake. I mean, sometimes you will have very clear evidence that someone is engaging in inappropriate behavior that violates your policy against harassment and discrimination. In the most severe case, you would terminate that employee, obviously. But I would recommend in cases where the evidence is not so clear, in fact, maybe you're not sure at all, at a minimum, I would remind the employees involved, if not the entire workforce, about the policy, maybe reissue the policy if it hasn't been distributed recently, and go ahead and get that out there and get it signed and dated again, so that if this turns into an EEOC charge in a lawsuit down the road, you still have your defense of what we investigated. There's no evidence that any harassing behavior was going on. Nevertheless, we still take it seriously. And even though we couldn't back up what the complaining employee was saying, we did remind our workforce that we have this policy and this is what's prohibited. So it can be a very helpful tool. Once you've decided on your action and taken it, it's important to get back to the complaining employee, let them know what your investigation revealed, let them know what action you took, and again, reassure them that they won't be retaliated against for making that complaint. And probably most importantly is to check back with that complaining employee periodically to make sure that there are no more problems or concerns. Again, a lot of times we'll see EEOC charges that say, well, I complained, no one did anything, it never got better. But if you have documented evidence that you went back to the employee time and again and checked in with them to make sure that they weren't having the continuing problems, you're really set up for a great defense. Okay, before we wrap up here, just a few quick tips that when you're talking to all levels of employees for that matter, just a couple of basic common sense things about conducting themselves in the workplace. First, if you've got something on your mind that you want to say or you want to do and you think it might be questionable, always ask yourself, is this something that you would do or say in front of one of your family members? If your grandmother would have slapped you for saying it, don't say it. If you wouldn't want someone to make that same type of comment to your child or to your spouse, then absolutely don't say it. And when you frame this issue for your employees and your managers in this way and make it very personal for them, I think that you can stop a lot of people from crossing the line when it comes to inappropriate behavior at work. Going back to the email issue, we really cannot stress this enough, and your employees and managers need to understand that as soon as they send an email or an inappropriate link, that is captured forever, and the last place they want to see it is projected in a courtroom in front of a jury, which is exactly where it will be. If it's a really damaging email, maybe you don't get that far down the road, but but the check's already been written. At any rate, I mean, this is just something that just needs to be drilled into your employees' heads because we continue to see it. If anything, this problem is getting worse, not better. Just being cautious. People obviously don't mind receiving compliments, and compliments aren't necessarily going to support an actionable claim for harassment, but that doesn't mean that makes the behavior okay, because some employee is going to take what you say wrong and can potentially turn it into a real headache for you. Finally, social functions. People really get tempted to relax, have a few drinks, engage in behavior that they wouldn't otherwise engage in the workplace. And unfortunately, even though the social situation makes it feel comfortable, the social situation does not relax the rules on prohibiting harassment. So if it's not something that would be said or done in the regular workplace day, it certainly shouldn't be said or done in the holiday times when the parties are going on. And this is really difficult to do. Nobody wants to be a Scrooge, but it wouldn't be a bad idea to remind your employees before you have a major social event, a holiday party, to remind them of the rules, the policy against discrimination and harassment, so that if something does happen, at least you said, we got to them first about it. And to wrap up real quickly, just to go through everything we did, remember your first line of defense is going to be having that comprehensive policy in place. Secondly, you want to make sure that every single person in your organization, from your lowest level employee to every upper level manager in the organization, understands what their specific obligations are under the policy, be it not engaging in certain types of behavior, be it if something happens, I have to take these steps to report it, be it if I hear of this happening, I need to report it, and this is who I report it to. So the training is really key in those areas, and particularly with your managers. Next, always be on the lookout, proactive about recognizing behavior that is potentially inappropriate and could be the basis of a harassment issue. If you go ahead and address those before you have a complaint, that also will reduce your complaints. Always be on the lookout for those non-traditional types of harassment. Again, harassment by non-employees, guests at your organization can certainly serve as the source of it. So always be looking for different types of harassment based on the protected categories that we all know are out there. And then finally, make sure that you've got that prompt investigation, that prompt response, no matter how trivial the complaints seem. If you've got the action in place, the EEOC certainly will reward you for that. A judge would reward you for that. A jury would reward you. Once you became aware of the issue, that you took prompt action, there's really no more that you can do than taking that immediate action. So if you have each of these things in place, we really think your harassment claims will drop off significantly. They will be stopped in many cases. And worst case scenario, because you're never going to be able to stop an employee from going to the EEOC and complaining about this, but if you've taken each of these steps in all of these cases, you'll be in the best possible place to defend a claim or a charge, and hopefully your legal costs will not be